Good evening to the aspirants of the All India Bar Examination, Cohort 17, 2023, which is going to be held on the 5th of February, 2023. And the last date, I believe, for the application is extended to 18th, if I not be mistaken. Anyone can unmute and read what I posted on the screen so that I could know that you are with me and I am with you. Both are sailing the same boat to reach to the destination. Quick. I said anyone can unmute and read what I posted on the screen.
Welcome to the aspirants of the AIBE 17 2023 today within the parenthesis Wednesday 18th January 2023. Virtual class from 9:10 p.m. to 10 p.m. Evidence.
Yes, that much is enough. That much is enough for the today. Okay, without wasting the time, let we go to our study because I put it in a red mark because 18th I completed, 19th that we have to start it. Be ready for shooting. 19th question. In today's technology-driven world, the case of Anwar PV versus P.K. Bashir and others, 2015 within parentheses, is a significant because the Supreme Court decided on the admissibility of electronic evidence in a court of law based on dash of the Indian Evidence Act 1872. Option A, 65 section. Option B, section 65A, capital A. Option C, section 65, capital B. Option D, section 65, capital C. Shoot.
C is right answer, sir.
65B is right answer, sir.
65C.
If you say the 65, capital C, it's the wrong answer.
65B is right answer, sir.
65B, sir. B, sir.
If you say
B.
option C, 65B, capital B, it is the right answer. So the right answer for the 19th question is C, section 65, capital B. Now 20th question. The court decided that the law of evidence is the legislation that does not impact the substantial right of the parties, but rather strives to facilitate justice for them. Option A, Om Prakash and other versus Bhagwan and others. Option B, Manzoor Ali and another versus Krishmat Ali and others. C, Ram Jas versus Surendranath. Option D, Kedar and three others versus Gobari. Shoot among the ABCD.
Option C, sir.
Read full.
Manzoor Ali and another versus Qismat Ali and others.
WRONG.
C is right answer, sir.
Read full.
Surendranath. Ramjas versus Surendranath.
Yes, it is option C is the right answer. Ramjas versus Surendranath is the right answer for the 20th question. That is a C. Okay, now 20. Oh, I did not number is 21. Yeah. Mangala woman Karandika defense TR and TLRS means legal representatives versus Prakash Damodar Ranade was decided on the basis of dash of the Indian Evidence Act 1872. Option A, section 19. Option B, section 91. Option C, section 92. Option D, section 93. Shoot! Your silence will kill me. Give the right answer, even though there is a negative marks.
D is right answer, section 93.
WRONG. Second option.
Sir, C, section 92.
Yes, section C 92 is the right answer. For the Mangala woman Karandikar case law. Now next case law. For example, whether a defendant was present at the scene of the crime is a question of dash. Whether mere presence meets the legal definition of a crime is a question of dash. So there are two dashes are there. In two dashes, option A, law and fact. Option B, fact and law. Option C, element and law. Option D, fact and rule. There are two dashes in the question. Example. Whether a defendant was present at the scene of a crime is a question of dash. Another, whether mere presence meets the legal definition of a crime is a question of dash. Now you fill. Say now.
Sir, option fact and law.
It's option B, fact and law is the right answer. The first one is a fact, the second one is the law. Then 22nd question. The court established a friendly relationship between the Information Technology Act 2000 and the Indian Evidence Act of 1872, holding the section 65B of the latter is complete code in the and itself, and that the former legislation and the statutory provisions of the Evidence Act as a legal machinery against the technological empowering. Now the option is A, Roop Kumar versus Mohan Tedani. Option B, Bhimsha Subanna Pawar versus State of Maharashtra. C, Arjun Pandit Rao Kotkar versus Kailash Kushan Rao Gorniantial and others. D, Kalyan Kumar Gagoi versus Ashutosh Agnihotri and another.
Sir, option B, Bhishma Subhana Pawar versus State of Maharashtra.
WRONG.
Option A, sir. Roop Kumar versus Mohan Thadani.
WRONG.
Sir, D is right answer, sir. Kalyan Kumar Gagoi versus Ashutosh Agnihotri and ANR.
WRONG. So the right answer is Arjun
Sir,
Pandit Rao Kotkar versus Kailash Kashan Rao Gorianchial and others is the right answer E for the 22nd question. Now 23rd question, anyone can unmute and read?
Confession to police officer not to be proved under section dash. Option A, section 22. Option B, section 23. Option C, section 24. Option D, section 25.
Option B, sir. Section 25.
Repeat.
Option B, 23, sir, section.
Wrong.
25, sir. Section
25
B.
is the right answer. Confession to the police officer not to be proved under section 25 of the Indian Evidence Act of 1872. 24th question. Yes, please give the chance to others though who did not read. Hurry up.
In which chapter of law of evidence where there are only two sections are dash? A, chapter 3, B, chapter 4, C, chapter 5, D, chapter 6.
Option B, sir. Chapter 4.
It's right. It's option B. Chapter 4 is the right answer for the 24th question. Now feedback. Here I have given chapter 4 of oral evidence, proof of facts by oral evidence, and oral evidence must be direct. Now the 25th question. Yes. Which section are there in chapter 4 of the Indian Evidence Act 1872? Option A, 57 and 58. Option B, 58 and 59. Option C, 59 and 60. Option D, 60 and 61.
C is the right answer, sir. 59 and 60.
59 and 60 is the right answer. Option
Yes, sir.
C, 59 and 60 is the right answer for the 25th question. Now, anyone can no, I will read it because it's the lengthy one. Okay. 26th question. Which option is the correct option? Number 1, 58, section 58, facts admitted need not be proved. 2, section 59, proof of facts by oral evidence. 3, section 60, oral evidence must be direct. 4, section 61, proof of document by primary evidence. Which option is the correct option? A. Option A, 1 plus 2. Option B, 2 plus 3. Option C, 1 plus 2 plus 3. Option D, 2 plus 3 plus 4.
Option C, sir. 1, 2, 3.
Yes, it is a section C, 1 plus 2 plus 3. Why? Because 61, proof of document by primary evidence, is a different section. Here I have given. That is a section 64, proof of document by primary evidence. But 61 is proof of contents of documents. Is it clear?
Yes, sir. Very clear.
Now, I will read 27th question. Which statement is the correct among the 4 options? A. The question is whether A committed an offense. The circumstances are such that the crime must have been committed either by A, B, C, or D. Every fact which shows that the crime could have been committed by no one else and that it was not committed by either B, C, or D is relevant. B. The question is whether A committed a crime. The circumstances are such that the offense must be committed either by A, B, C, or D. Every fact which shows that the crime could have been committed by no one else and that it was not committed by either B, C, or D is relevant. C. The question is whether A committed a crime. The circumstances are such that the crime must have been committed either by A, B, C, D, or every fact which shows that the offense should have been committed by no one else and that it was not committed by either B, C, or D is relevant. The last question statement is D. The question is whether A committed a crime. The circumstances are such that the crime must have been committed either by A, B, C, D, or D, or every act which shows that the crime could have been committed by no one else than that it was not committed by either B, C, or D is relevant. So total I read A, B, C, D options. Now you tell me which statement is correct among the 4 options.
All are looking same, sir.
No.
No. All of
For instance, you take here, for an offense, here a crime. So now difference is whether this is right or that is right. Number 1. Number 2, here I wrote, for instance, here again I wrote offense. Here I offense. But there it is a crime. Now this one correct or this one correct? In the C, committed a crime, I wrote it. Such a crime has been committed by ABCD or fact which shows the offense. I wrote offense here. But here it is a crime. Now which one is the correct one? D. Here I did not write the offense here. Crime is there and shows the crime is there. So what is the right answer?
D is right answer, sir.
D is the right answer. Supplementary question. Which section of the Indian Evidence Act 1872 is the above statement? The statement which I have given is the Indian Evidence Act, one of the example or one of the provision. Which provision it is? I give the here feedback. Section 11, subsection 2, clause B. The Indian Evidence Act 1872, which I just before read. Is it clear?
Yes, sir.
Yes, sir.
I don't know why this has come. Just a minute, just a minute. Share. Oh, I have to close it. Unnecessary distance. Come. Okay, no matter. Huh? Share content because the WhatsApp is opened. Yeah, could you see my screen now?
Yes, sir. Very clear.
Good, good. Because the WhatsApp is opened. So it is creating. So I closed it. Actually, I have to close it. Anyway, it doesn't matter. Yes, the next question is 28th question. Match the following part A section and the decided case name in the part B. So now sections are given the part A, section 61, section 145, section 162, section 173. In the part B, the number of the cases held under the sections. Gulzar Khan versus State and Emperor versus Aftab Muhammad Khan. C. Bhagwan Singh versus State of Punjab. D. Ashok Dulichand, Madhavalal Dubey and others. So it is option part B is the decided cases and part A is the section. Now options are A, option A 1C 2A 3B 4D, B 1B 2A 3D 4C, C 1D 2C 3B 4A, D 1B 2D 3A 4C. Shoot.
Option C, sir.
Which section? Yes, please.
Option C.
Option C is the right answer. It is 1D, 2C, 3B, 4A. Because feedback it is given. 65 is Ashoka Durichan case law versus Madhavalal Dubey and others. Section 145, Bhagwan Singh versus State of Punjab. Section 162, Emperor versus Aftab Muhammad Khan. Section 73, Gulzar Khan versus State. These are the leading cases and these are the sections which dealt about it. Now 29th question. Which pair is mismatched in the following section and the respective case law? There is a mismatch is there. I gave the section in the part A and in the other side I gave the case law, decided case law. But one case law is not matched. And the options which I goes in this way. Option A, section 7, state within parentheses NCT of Delhi versus Navjot Sandhu alias Afsan Guru. B, section 113 capital B, Mafatlal Industry Limited and others versus Union of India and others. Option C, section 27, Tambi versus Emperor. Option D, section 32, subsection 5, Subbaya Mudaliyar versus Gopala Mudaliyar. And which is mismatched case law among the A, B, C, D? Shoot, even though it is wrong. Participants, are you there or not? Why you are so silent?
sir.
Your silent
Yes,
will
sir,
kill
yes.
me.
Right? Yes, sir.
I say shoot.
Option A, sir.
Wrong.
Sir,
This option
option
is
B,
right.
C.
Huh?
Next. Only one is wrong among the A, B, C, D. Others are right. Shoot.
Sir, can you please scroll up the screen? I'm unable to see the options.
No, it is there. It is visible. It is visible.
It's only one.
Only down is only one, but other options are clearly visible. Yes, I will give the answer. It is a Tumbi versus Emperor. No, it is a Kottayam versus Emperor. Kottaya versus Emperor. Others are the same. I don't know whether you know Mafatlal Industries. It is a cloth industry like Bombay dyeing. I used a section 27 Tumbi versus Emperor, but actually mismatched one is section 27 is Kottaya versus Emperor is the right case law. So mismatched one is
Option C.
option C. Yes. Now 30th question. Conclusive proof. Which is the correct one among the four? I read the A. Which one of fact is declared by this act to be conclusive proof of another? The court shall, on proof of the one fact, regard the other as proved and shall not allow the evidence to be given for the purpose of disproving it. B. When one fact is declared by this act to be conclusive proof of another, the court shall, on proof of the fact, one fact, respect the other as proved and shall not allow the evidence to be given for the purpose of disproving it. C. When one fact is declared by this act to be a conclusive proof of another, the court shall, on proof of the one fact, regard the other as proved and shall not allow the evidence to be given for the purpose of proving it. D. When one fact is declared by this act to be conclusive proof of another, the court shall, on proof of the one fact, regard the other as proved and shall not allow the evidence to be given for the purpose of disproving it. Shoot, which one is the correct answer among the four? Yes?
Sir, option A.
Option A is the correct answer. All other options are wrong answer. Because somewhere I twisted it. For instance, A and B, where I twisted, can you tell me?
Sir, in A, in second line, regard. In B, respect. Respect
Right.
is wrong.
And so
In
these are the
there is
somewhere I twisted it. And only the IQ man can make it out, which is the right answer for that one. Is it clear?
Yes, sir.
Yeah, now, 31st question. The Indian Evidence Act, Amendment Act of 2002, Act number dash of 2003. Options A, 1, B, 2, C, 3, D, 4. I say Amendment Act 2002. I did not say 1872 Act. Shoot.
Option D, sir. 4.
Option D is the right answer. Option D is the right answer. I appreciate a good knowledge. Okay. 32nd question. Full bench of the Punjab High Court has observed in dash that section 27 constitutes a proviso or an exception to the section 24, 25 and 26 which bar confession made by the accused person in certain cases. Option A, Rama Siddhappa versus the state. Option B, state versus Lehana Singh. Option C, Ram Ratchapal versus state. Option D, Ganu Chandra Kashid versus emperor. In which case law it is decided? Punjab High Court.
Sir, option B. State versus Lehna Singh.
Option C, sir. Ram Rajapal versus state.
C, Ram Rajapal versus state is the right answer. Of course, May I know that how could you use a trick? Did you read the case law somewhere or you used my technique? What is your answer?
Just
Sir,
guess, sir.
only technique, sir, which fall by name and state.
See, even though you don't know the answer, but you can, by using my technique which I trained you, you can shoot the right answer without any confusion. Yes, 33 question. The term evidence is defined in dash of the Indian Evidence Act 1872 as both section 31 oral and written evidence. Option A, section 30, option B, section 31, option C, section 32, option D, section 33.
Sir, option A, section 30.
Wrong. See, the question itself is having the answer.
Option B, sir,
Section
31.
Option B. Option B. The question itself is having the answer. Okay. Now the 34th question. Yes, I twisted it. I would like to see your IQ. 34th question. This understanding principle of evidentiary law is called the best evidence rule, also referred to as the original writing rule. The foundation of the best evidence rule is that dash is that best way to prove the actual content of the evidence. Option 1, the original evidence, original writing. Option 2, recording. Option 3, statement 3, snapshot. And statement 4, photograph. Here I have given the options. Option A, 1 plus 2 plus 3. Option B, 2 plus 3 plus 4. Option C, 1 plus 2 plus 4. Option D, 1 plus 2 plus 3 plus 4.
Option C, sir, 1, 2, 4.
Option C is 1, 2, 4. Because there is a original writing is there, recording is there, photograph is there, but snapshot is not there. Because I concocted, fabricated, falsified. Okay, 35th question. Oral evidence refers to all remarks that witnesses are allowed or required to make before the court in regard to the facts under dash. A, study. B, examination. C, search. D, investigation.
Option B, examination.
Wrong.
A is right answer, sir. Study.
Wrong.
Option D, sir, investigation.
Option D, investigation is the right answer. 36th question. The confession of an accused person against a co-accused is not evidence in the ordinary sense of the term. It does not come within the meaning of the evidence contained in Section 3 of the Indian Evidence Act, is as much as it is not required to be given on oath nor in the presence of the accused and cannot be tested by cross-examination. And this was decided in the case of option A, Naresh Agarsin Chhara versus Naryo versus state of Gujarat. B, Muhammad Ilyas and another versus state of Chhattisgarh. C, Monu Tawait versus state of Chhattisgarh. D, Kashmira Singh versus state of Maharashtra. State of Madhya Pradesh.
Option D, sir, Kashmira Singh versus State of Madhya Pradesh.
Kashmira versus state of Madhya Pradesh is the right answer for the question D. 36th question. So, these are the way I prepared today the questions, and I told you that once I prepared the same, I cannot repeat it. If I repeat it also, I repeat in a different direction, different notion, different mode, different angle, different perspective, and then ask the question, if I repeat also. So, these are the things. Now the time is, I believe, yes, in India it is 9:42 and in Tanzania it is 7:12. So we started the class at 9:10. Still, we do have some 5 to 10 minutes with us. But let us see that what we can do for this one. So the next class is, I already posted on the screen. What is the next class?
ADR, Alternative Dispute Redressal, including Arbitration Act.
Yeah, it is a 4 marks question. Hence, only one time means one day that I would like to make that thing. Yes, so still some time is there. I don't want to waste my time. I would like to show some other things because Law of Evidence Bare Act, yes, it is here. In the Bare Act, of course, cases, but I try to make it out. But you also try. How many times Law of Evidence is amended? I could not get it, but they say it is 2002 is the amendment. But which type of amendment? Number, is that 15th amendment or 18th amendment or 20th amendment? Please try it. Because I could not trace it out in proper way. Otherwise, I waste, of course, because I have to teach 3 courses here now. Because one more course is added to me. So total 4 courses I am teaching for the masters. And that to be 2 are physical and 2 are online. So online is no problem at all. Physical means I have to come over here. And today I came to the university. I'm teaching you from the university now. Okay, now let us come to the point. The probable questions are there. See, here 81A is there. See, did you see it? Such questions, sometimes they will frame it. What is section 81A says? And here you see, probability is there. A question may be asked from here also. They will write from 85 and they say match the following, and they mismatch it or they match it. From 85 to 80, see this one. Capital A, capital B, capital C, and 85, single 85. So, probability I am giving it. And most of the time that I already told you that the way that question can be framed. Because when I look at it, I would like to see that the question should be framed in a different style, which is not seen in any book, or probability there that going to be asked in such a way also. So that there is a permutation and combinations to are asking the things in a different styles and different way. See, today I did not ask you what is the Act 1872, Act number 1 of the Law of Evidence, but I asked the amendment. Is it not? Which amendment it is? Anyone? I asked the question amendment. Can you tell me which amendment it is? I mean the year. Yes, year. Why you are keeping quiet? Are you hearing me?
Yes, sir.
But you are not giving the answer.
2002 of 23 of 4, sir. 22 Act.
Yes, 2000. Yeah, 2000.
19, sir.
No.
2002, sir.
Is it 2002? No,
Yes, sir.
not 2002 also. Oh, let me check it. I think to my knowledge, it is 2002 as far my knowledge goes. But anyway, let us check it. Yeah, I am right. It is a 2002. It's the act number. Because I peculiarly I found it. Better you ask this because students will not know. Definitely. And no one has shooted in a proper way for this question. Am I right? Yes. Say.
Yes, sir. Yes, sir.
Yes. So now we will see that What is the proof? What is the concurrent proof? What is the res judicata? What is the estoppel? They may ask also, they give the example of estoppel. And they ask whether it is a estoppel will work over there. They may ask also there. Yes. Anyone can give me the answer for the what is meant by estoppel? In your own terminology. Once you said, you have to stick to it and you cannot reverse it. Is it clear?
Yes, sir.
Once you said, you should accept it and you obey it. You cannot say deny it.
Yes.
That is the estoppel. So, this way that we can make it, okay, who will be called accomplice? Accomplice. ACCOMPLICE. Yes?
Witness, sir.
No. Accomplice means a person who take part in the event or an action.
Mhm.
For instance, you say, here I saw accomplice. See, 113 is there. 133 is their accomplice. So if you happen to see the accomplice, find fault. Yes, 133.
Yes.
So directly we can go to the 133. See, accomplice means an accomplice shall be competent witness against an accused person, and a conviction is not illegal merely because it proceeds upon the uncorroborated testimony of an accomplice. Means here not the person who is taken part in the event, but an accomplice shall be a competent witness against an accused person. It is an against accused person, and a conviction is not illegal merely because it proceeds upon the uncorroborated testimony of the accomplice. Uncorroborated means not supported with. Not supported with, unincorporated. So sometimes when direct witness is not there, then the circumstantial witness can be taken into consideration. Or even a police record also be taken into the consideration. When there is no proof is there, evidence is there. So that is the way also they can make it out, accomplice, who is an accomplice. And if you could see the illustration, see the illustrations are given, A, B, C, D. Sometimes they can ask it, illustration, and they say whether it is a proper or not. For instance, you take, A is accused of receiving the stolen property knowing to have been stolen. So whether this statement is the right statement or wrong. So that way also they can ask the question, and it is proposed to prove that by a copy of the comments of the document said to be lost. So these are all the provisions would be there, illustration A, B, C, D. And these illustrations comes under the 136 section, judge to decide. Yes, now also the people are waiting in the lobby. Yes, 136, judge to decide of admissibility of evidence. At that instance, they have given at least illustration A, B, C, D. And here I have taken, I think, is it this one I have taken the example? No, it's a different one I have taken. It is a section 18, subsection 2, and class B I have taken. And this is a different one. Because there also ABCD is there. Is it not?
Yes, sir.
Here, this I have not taken the example. I have taken the different example. Yes, they can ask the question also, examination in chief, cross-examination, re-examination. Because all the examination chief, cross-examination, re-examination, they will keep it at the left-hand side, and its explanation, they will keep it the right-hand side, and they will ask you the question, match the following or mismatch the following. Of course, they eliminate his cross-examination. They will eliminate his. They say his dash. The examination of the witnesses by the adverse party shall be called the cross-examination. They don't give in the right-hand side the cross-examination. They give only shall be called his dash. Dash means dot, dot, dot. Otherwise, you know that what is the cross-examination. By reading this one, you can easily match it, whether it is a proper match or not. Are you following me?
Yes,
Yes,
sir.
sir.
They don't mention the
Can
examination
we get
there.
this PDF, sir?
Yes?
Can we get this PDF, sir?
What PDF that what I am showing you is already there in that. I am showing the PDF as the only bare act.
Okay.
I am showing the only the bare act of the law of evidence. Do you want that it is should be given the PDF? Shall I attach to it? You can tap it from the Google also. Am I right?
Yes, sir.
Or I can post it, doesn't matter. I will post you. Of course, one should have to have the knowledge of this. All bare act, you keep in the soft copy. But never ever take any book in your hand. Please note the fundamental rule. Don't take anything. Just listen my classes. I will cut my nose if you don't qualify. It's an open challenge. If you participate in my classes, if you don't qualify, I cut my nose like a surpanaka. It's my open challenge. And it is recorded also. Because I do have the confidence. I am training my students in such a way, they can, even they don't know the answer, they can shoot it without having any confusion. Am I right?
Yes, sir.
Yes, sir.
See, that's why I'm showing you. They remove the re-examination, they remove the cross-examination, they remove the examination in chief, and they can ask you the question. And it is you, if you know the gist of it, you can know, oh, this is the examination in chief. Okay, this is a cross-examination. Okay, this is a re-examination. Because you read the first content of it here. These contents give the sense to you that what you read and what is the right answer for that one. Is it clear?
Yes, sir.
Yes, still we do have at least 5 minutes in our hand because we started at the 9:10 and it's the 9:55 now, India time. Okay, so this is the way I'm training you to make it out, how the questions will be framed and how you have to give the answer for that one. And if you see the witness's character may be cross-examined or re-examined. So they may make it out. Witness character may be dash. Number 1, cross-examined. Number 2, re-examined. Number 3, chief examining. Number 4, all of the above. Are you following me? See, I framed it. Just now I framed the one question, multiple choice question to you. Because I added chief examination also. I added all of the above. The people generally saying that they are all of the above. No, it is not all of the above. It is only the 2. As per the section 140 is concerned. Because they will write in section 140, witnesses to character. Witnesses to character may be dash. Number A, cross-examined. B, re-examined. C, chief examined. D, all of the above. So people definitely will make it out D, all of the above. But they don't know that there is no chief examination under section 140. Am I right?
Yes, sir.
Yes, sir.
Then the leading question, we already told you. What is the leading question? A leading question have its own answer in the question itself. And that is the leading question, which give the prompt the witness to expect the answer should be given. So that is the reason they say the leading question should not be asked to the witness. If it is asked, the opposite party make an objection. So depending upon the question, the judge will make it objection is overruled or objection is sustained. Is it clear?
Yes, sir.
So what the judge having in the hand, that the wooden hammer is called? The wooden hammer in the hands of a judge or auctioneer is called? I already told you, I don't know how you forgotten it. A.V. Rao. Give me the answer. Have anyone taken the screenshot of the today's attendance?
Yes, sir.
A.V. Rao is not present, it seems. Are you present, A.V. Rao? No, he is not present. He disappeared. Gavel, G-A-V-E-L, gavel. A wooden hammer which is generally in the hands of a judge or an auctioneer to break the silence or make the disturbance to be silent, to make the warning, to make the attention, and beating on the sound peg. So the down one is called sound peg, the upper one wooden hammer is called gavel, G-A-V-E-L. Okay, with this I would like to wind up my today class, and you can post me my screenshot where the maximum members are there. So thank you very much. In Kiswahili, asante sana. Then goodbye, koheri in Kiswahili, and Jai Hind, that is end of the meeting.
सारे जहां से अच्छा हिंदुस्तान हमारा। जय हिंद।
Jai Hind.